മാനവഹൃത്തിൻ ചില്ലയിലെല്ലാം മാൺപുകൾ വിടരട്ടെ. മനസ്സു നന്നാവട്ടെ, സൗഹൃദ സിദ്ധികൾ പൂത്താൽ സൗവർണാഭ പരന്നാൽ. സൗഹൃദ സിദ്ധികൾ പൂത്താൽ സൗവർണാഭ പരന്നാൽ. സുരഭില ജീവിത മാധുരി വിശ്വം സമസ്തമരുളുകയല്ലോ. ഓ മനസ്സു നന്നാവട്ടെ, മതമേതെങ്കിലുമാവട്ടെ. മാനവഹൃത്തിൻ ചില്ലയിലെല്ലാം മാൺപുകൾ വിടരട്ടെ. മനസ്സു നന്നാവട്ടെ, സത്യം ലക്ഷ്യമതാവട്ടെ. ധർമ്മം പാതയതാവട്ടെ. സത്യം ലക്ഷ്യമതാവട്ടെ. ധർമ്മം പാതയതാവട്ടെ. ഹൈന്ദവ ക്രൈസ്തവ ഇസ്ലാമികളുടെ കൈകളിണങ്ങിയിടട്ടെ. മനസ്സു നന്നാവട്ടെ, മതമേതെങ്കിലുമാവട്ടെ. മാനവഹൃത്തിൻ ചില്ലയിലെല്ലാം മാൺപുകൾ വിടരട്ടെ. മനസ്സു നന്നാവട്ടെ, മനസ്സു നന്നാവട്ടെ, മനസ്സു നന്നാവട്ടെ.
Never mistake law for justice. Justice is an idea and law is a tool. Quoted by L.E. Morrison. Respected Principal Sir, Mr. Krishna Kumar, Chief Guest of the Day, Sir Suresh Kumar, Sir S. Prabhu Sir, Sisi Ma'am, our Program Officer, Lowellman Sir, dear teachers and good friends, good afternoon. As a part of the NSS family, I welcome you all to this propitious program. We have all gathered today to be a part of the awareness program on the insolvency profession. So without any further delay, I welcome Ms. Mehnaz for the welcome speech. Please. Good afternoon, friends, faculties, and everyone present on the dais. It's encouraging to see you all. So excited to receive all the immense wisdom from our guests present here. I would like to thank everyone for your presence here. So let me give a brief about our honorable guest. He is a fellow member of Institute of Chartered Accountants of India and a former chairman of Coimbatore chapter of Institute of Chartered Accountants of India. He is an insolvency professional with an experience of 15 years. He is the founder partner of SPP and Corporation. He specializes in direct tax advisory and litigation practice, fundraising and financial advisory. In the corporate field, he is the leading advisor in various business ventures. Let us give a round of applause to S. Prabhu, Chartered Accountant. It is a pleasure to have you here, sir. Thank you.
Dear students, now let us hear from our chief guest, who is expected to inaugurate this function, Mr. Suresh Kumar. Okay, Mr. Prabhu, he is professionally a chartered accountant, and at the same time he is a practicing profession in this area. He will be able to give a guideline or an outline as to what is this Insolvency Act, how this is being implemented, how company matters are dealt by courts, and after that how the case comes to their field, their area, their hands, and after that how the liquidation process will be held by official liquidator. All these things, he will give you a bird's eye view over the subject, That will be followed by a detailed session led by Mr. Suresh Kumar. He is also a chartered accountant and a insolvency professional. So both of them will give a detailed idea on the area. So with this I would like to invite Mr. Prabhu to elaborate this issue. Please.
Dignitaries on and off the dais, my dear students, faculty members of this prestigious Calicut Law College, it's a pleasure for me to address before you on this inaugural function on the function that is being conducted under the Azadi Ka Amrit Mahotsav under the aegis of Insolvency and Bankruptcy Board of India, and also the IIIP ICA, it's an IPA under which myself and Suresh are part of the IPA. So we are happy to stand before you and express a few things and ideas about what insolvency professions are, what the IBC code is all about, and we are happy to be here today. Before the PPT gets ready, I'll just give you a brief of why this insolvency and bankruptcy code has been brought into India and what is the importance for it as a nation as a whole. As I was talking to the principal sir in the afternoon, see, India has got a lot of non-performing assets, maybe because of some bank dues, some companies have gone bad, because of some supplier issues, some litigation. Many of the ideal assets are there in India, where we don't put the assets to proper use, which has been all imported and we developed our own resources, which are all lying idle. As per one statistics, almost $2 billion worth of assets are being there in India, which has not been properly put into use, is lying idle, which is a national waste. So the central government thought we'll have to make it of use and we'll have to make sure that it has been put in proper hands so that we can generate employment of 2 crore as the central government has been budgeted for a year. So keeping these two things in mind, the Insolvency and Bankruptcy Code was devised, and the governing body for this Insolvency and Bankruptcy IBC code is the Insolvency and Bankruptcy Board of India. So what happens is IBBA has formulated 3 IPAs. One is the IIIP ICA, of which we are also a part of it. Our membership has been granted by the IIIP ICA, along with 2 other IPs are there, which is formed by the Company Secretaries Institute and the Cost Accounts Institute. So the whole process is whenever there is a company that has gone bad, either it can voluntarily approach to the National Company Law Tribunal, or through the suppliers or through the creditors, or lend the money to the company. They can approach the NCLT and file a case against the company, and if the liability is more than 1 crore. So what happens is the company will be, the management of the company will be taken over by NCLT and will be handed over to a professional like us who are qualified as an insolvency professional. To get at present, to qualify as an insolvency professional, all you do has to have 4 professional, either one of the 4 professional qualifications, either chartered accountancy or a cost accountant or a company secretary or a lawyer. That is why we are in law college like in Calicut, where because of almost some 5,000 insolvency professionals are there in India as of now, but nearly only a handful of lawyers are practicing in insolvency bankruptcy code. Not many are coming forward to practice in insolvency code. So that is why the IBB has taken initiative asking us to go and talk to various law colleges across India to bring lawyers into the fold, because like the chartered accountant, where we have a specialist in some field, advocates and lawyers have a specialist in many legal matters. So only when the advocates and lawyers come into the fold of IBC, the whole gamut of the idea of IBC is getting fulfilled. So that is why we have been delegated to talk to you. So once you're any one of the 4 professionals, if you have 10 years of post qualification, you will be eligible to write an exam. Once you get to that exam is a negative mark exam, it's a 2-hour exam. Once you get qualified for the exam, then you'll have to go for a 50-hour training course. It will be held in various places in India, conducted by various of IPS. So once you complete the 50-hour course also, then you can apply for the membership. And once you get the membership, then again you'll have to apply for AFA, that is called Authorization for Practice, to act as an insolvency practitioner. Once everything is complete, then you will have to apply for the empowerment various banks and financial institutions. And whenever there is a company that has gone bad or insolvency case has been filed against any company, the NCLT will appoint you as the insolvency professional. That is where your whole job starts. After getting qualified and after getting empowerment and after the case has been allotted, that is where the work as a professional starts for you. So what is the profession that you have as a professional? You have to take into control the whole assets of the company, the management of the company. Once you get appointed as the insolvency professional of the company, the directors of the company their powers will be suspended. So you will be there in the shoes of the directors and management of the company. So you will have to take care of the affairs of the company, get all the claims submitted, all the you'll have to see what are the liabilities of the company, what are the assets of the company, and you'll have to see whether the company is viable or not. If the company has become viable, then you will have to go for you'll have to bring in some investors who will be in place of the existing promoters. Those people will come into the management and they'll take out the assets and make it as a productive asset. And if that process is not working, then you'll have to go for the liquidation process where the company's asset will be liquidated, that is being auctioned, and the liabilities will be settled to all the creditors. This is the whole process. The main the preamble of the IBC Act 2016 reads as follows. It is an act to consolidate and amend the laws relating to reorganization and insolvency resolution process of corporate person. As of now, the law talks only about the corporate persons. You might be understanding what a corporate person is. Only a private limited company or a public limited company or an LLP. Only these persons will come. As of now, only these three category of companies will come into the insolvency. In the future, the law is going to extend for partnership firms and also for individuals. That is where the real demand and the requirement for insolvency profession will increase. Because as I told you earlier, only 5,000 companies, insolvency professions are there as of now. But that is not enough when the insolvency process starts for an individual or a partnership firm. So as of now, the law is notified for partnership firms and individuals, as you can see in the preamble of the Act, but it has still not been notified. It is a time-bound manner for maximization of the value. That is what I was supposed to tell you a little bit earlier. Because in most of the cases, what happens in India is no law is time-bound. Everything takes a very long time for getting settled. As per one statistics, when the company is required to be wound up voluntarily, normally it takes 4 to 4.5 years time. That is not the case in any other places around the world. It takes only 6 months time to wind up a company. But even to just wind up a company, it takes at least 4.5 years in a company. And some cases when there is a non-performing asset in any bank, what happens is the time taken is almost 7 to 8 years to get the loan settled for the creditors and the bankers. So this is actually national rate for the bankers and also for the suppliers and everyone. So that is why the preamble says it's a time-bound manner. In an IBC, everything has to get completed by 180 days from the day of approval of the order by the NCLT till the end of the process. It's only 180 days time. Within this 180 days time, you will have to complete the whole process. On exceptional situations, you can extend to another 70 days time, 90 days. So maximum 270 days, this process has to get completed. So everything is kept in mind, the time is kept in mind so that unnecessarily there will not be any litigation. All the scopes have been given away. So that is one thing. And one more thing, once the scheme is getting approved by the NCLT and the new management takes in, all the liabilities of the old companies gets extinguished. The new promoters will be only liable for whatever the liabilities they are taking over. So they have very free hand in handling. That has also been mentioned in the preamble. If you can see, availability of the credit and balance in the interest of all the stakeholders. The CRP IBC code is planned in such a way that all the stakeholders in an issue. For example, in a corporate case, the stakeholders will be the employees, the creditors, the suppliers, the bankers, management, government use, everything, all the interest has been taken care of. There is an arrangement where in the liquidation there is a mechanism through which you can settle the liabilities. That's called as waterfall mechanism. First, the primary security is given to the secured creditors. Only the assets are there. The first secured creditors will be settled. Then the unsecured creditors. Then the employees. Then only the government dues come. Government comes as the last thing. So the preamble sums up what the intention of the law is. So this is the step of becoming an insolvency professional. First, as I told you earlier, you need to have 10 to 15 years post-qualification experience. Either you be a lawyer or an advocate or a cost accountant, or a company secretary or a chartered accountant, 10 years post-qualification experience has to be there. Only then you will be eligible for writing this exam. Now there is a new law that has been brought in the insolvency code that is called as the graduate insolvency program, on which my partner Suresh will be elaborating. Once you qualify as any of these four professional qualifications, but you don't have 10 or 15 years experience, then you can go directly for the graduate insolvency program. That is a college-based education where you have to attend the college on a daily basis. It's a 2-year course. Fee structures, everything will be elaborated by Suresh. So those who are qualified as a professional but don't have a 15 years qualification, they can go for this graduate insolvency program. Once you get qualified as a graduate insolvency program, then you can directly go for the registering for the as an insolvency professional. And one thing what the IBBA or any of the IPS like the IIIPA is looking for is persons of very good character and reputation and integrity, because you are going to deal with the national assets of the national assets and going to deal with all the liabilities. So they ensure that you are clean of any of the liabilities. For example, many of the professionals might have taken some loans, they might have some civil issues, even small civil issues, or if you have, then you will not be eligible for becoming an insolvency professional. So you will have to be personally very integral and of good character to become an insolvency professional. Then comes the limited insolvency exam. You will have to get qualified the exam. It's a 2-hour exam, as I told you earlier. It's an online exam. It has got negative marking. Immediately once you complete the exam, you will come to know whether you got qualified in this exam or not. Now there is an amendment I was told by Suresh that usually every other day you can go and write an exam. Now it's not like that. Once you don't get through an exam, 2 months you have to wait. Only then you will be able to write the exam. And once you get to the exam, then you will have to register with the insolvency agency. As I told, as of now, there are only 3 insolvency agencies: IIIPICA and Insolvency IPS of company secretaries and IP of cost accountants. And once you get enrolled as from the IPS, then you will have to go for registration with the IBA, where they give you an authorization for acceptance of your only proposals. Only if you have an AFA, you'll be able to go for a practice. That is the final leg. Once you get an AFA, then you can enroll as an insolvency professional. This is an elaboration on the graduate insolvency program. For this only we are actually conducting this program because we need many students to register for this GIP. GIP eligibility for GIP is only as of now when we are talking to law college students. Once you get qualified as a lawyer, you will be eligible for the GIP. It's it's one of a kind of program for aspiring to become an insolvency professional. It's a 24-month intensive classroom based. It's not a distance education or a virtual class. You'll have to go and attend the classes. As of now, the classes are held in Delhi, but very soon I think it will come to all over India. This is an opportunity for students who have completed the law and other professional bodies and without having 10 years experience. As of now, classes are happening in Bhopal, not in Delhi, sorry, happening in Bhopal. Once you get qualified as the GAP, then you will be eligible to get practice in this thing. So it is a very vital program that most of why we are coming today, as I told earlier, is not many advocates and lawyers are coming into the practice of insolvency profession. We need not many students So on this occasion, I request all of you to kindly go through all the brochures that we handed over to you, and it will be a very wonderful program. And as the principals are also asking, what will be the remuneration or how the package for this industry will be there. Actually, compared to what a chartered accountant or advocate or a cost account earns in the normally, once you get qualified as a insolvency professional, the fee structure is totally different. It's all pre-fixed by the IBPA and IPA. And in fact, when you go for liquidation, you are paid in the percentage of the realization that you have. So financially also, it is a very good profession. And all other countries apart from India already have this profession, and they're really doing financially well. So as far as financial this thing also support also, it will be a very good profession for all the graduates. With this, I take leave and I thank the management for giving me this opportunity. Now I request this session will be taken over by my partner Suresh Kumar. Thank you very much.
Guest, a fellow member of Institute of Chartered Accountant of India, who is currently practicing as partner in SPP and Corporation in Coimbatore. He is practicing professional insolvency and registered valuer for financial assets class. His area of specialization includes FEMA, Foreign Contribution Regulation Act and Foreign Trade Policy, financial business valuations, transfer pricing and international taxation, insolvency and bankruptcy matters and commercial arbitration. Let's give a heartwarming welcome to M. Suresh Kumar, Chartered Accountant. We are immensely grateful for your valuable presence. We are hoping that you will ignite the fire in us with your vast knowledge. Thank you, sir.
Good afternoon, fellow professionals. Good afternoon. Okay, they have given me a brief introduction, so I don't want to repeat what things. So you are all future lawyers, maybe down the line in 1 year, 2 years, 3 years, you will be at various years. How many of you want to practice corporate law as your specialization in law practice? Very few. Only 1 or 2. Corporate law. So all want to practice civil criminal only? So that it looks like you don't want to make any big money. This corporates only will pay you big fees. Remember, all the civil criminal matter very rarely, very few cases will fetch you. Corporates only will pay you big fees. So very few are interested in corporate law. Okay, let me try to motivate you to corporate law practice in the next 1.5 hours of session. It's post-lunch session, maybe a little bit boring. I try to keep it as interactive as possible. See, the objective of this insolvency code and the objective of today's program mainly is to contribute for national building. Okay, that's the key objective the government drives it. That's a word we hear in every nook and corner. But how that will be possible? That's the question before all of us. This Kerala, though, it's very famous for all kind of communist approach where we will have union, so many things. We are coming from Tamil Nadu, so not that much of unionism and those things. But historically, we have seen in our place, maybe because of union activism or because of some financial crunch, many assets have gone idle. In the sense, factories have closed, never got opened. At least in Coimbatore, where we are there, it had about 100 plus textile mills historically. And all the large mills, which have been established 30-40 years back, nothing is there today. Only real estate is there. All mills are closed for various reasons. Maybe the product or methodology they used to manufacture would have become redundant, or workforce not viable, taxation system, or financially they don't have wherewithal to run the show. So it's all closed. Literally, all large scale textile mills which are there in 1970s and 80s, everything is closed. Okay, now in the outskirts of Coimbatore, many textile mills have come, but the historical textile mills are gone. Still now those assets are lying idle. Almost all the assets are lying idle, not used at all. This is just a small case in Coimbatore. Just imagine across India, over the years, how many assets are built and lying idle. You will be seeing in your own area, some factories would have operated. Your parents might be seeing that in that company only I got that, my grandfather worked, but that's now closed. Maybe for some reason it is closed. Just imagine in the angle of the country where we are 100 plus crore, means 130 crore plus population is there, you have to give employment opportunity for them. To give an employment opportunity, you want to engage some 100 people for some factory work, you have to invest at least 5 crores. Only if you invest some 5 crores in land and building, infrastructure, machinery, you will be able to employ some 100 employees to give it up. And just imagine you have to feed 130 crore people in India, how much employment you have to keep on generating. And the employment gets changed over the years. What was done historically, it is no longer there. Just imagine another 20 years, the driving profession will not be there. Today, India has about 40-50 lakh drivers. In another 25 years, there is no drivers required because everything will be automated. For them, there will be some opportunity has to be created. Like that, employment, the modalities are getting changed. In that way, industries are getting closed and some new industries has to come. But the problem is all these industries getting closed doesn't revive or doesn't get converted into a new company and this asset goes waste. It was a problem there even in the coal allocations. Many agencies got the coal allocation, but they were not able to use it off. So they are sitting with the coal allocation. Same way, there is a problem with spectrum allocation. So there are telephone companies which got the spectrum allocation, but they didn't have funds to run the operation. So that allocation, whatever they got for any particular region, geography, that was not at all commencing. We are not coming to know about it, but in reality, as a national level, many of those resources are going waste because some enterprise takes it and sits with them. It doesn't put it to use. Their bank loans would have gone into default, so further bank will not be supporting, so they don't get any money, it gets stuck. The problem, bank has huge money, even if it gets stuck also they can survive. But imagine employee who is working there for 3 months, for 1 year, 2 years, his salary, last few months salary would have stuck, his retirement benefits would have stuck. Next, suppliers, they would have given credit to them, the suppliers' money is stuck. Asset lying idle, all these people's money gets stuck, completely collapsing the economy. In this pattern, about 20% of the assets of the country are lying idle. This 20% can generate employment between 2 crore to 3 crore minimum in the country. And it can be, if it is productive, your GDP will be further 20% high. Whatever GDP, every year we say, we target down to $3 trillion and we wanted to achieve $5 trillion. And if we sit with this idle asset, we will never be able to achieve those targets. So that is one of the agenda government wants to put all these assets into use. And your question will arise, how this insolvency law will contribute? Because these insolvency laws are historical. You know, in 1910, 1920, some provisional insolvency laws are there, enacted by the Britishers. Subsequently, Partnership Act 1932 also had a provisions for insolvency for partnership firm, and Companies Act has its own provisions for the insolvency process. And bankers, to realize their money, bankers enacted SIC Industrial Provision Act, a Recovery of Debt Act. Every 10 years, one or the other recovery laws used to come. RBI, central government used to do one or the other stories to recover all these defaulting assets. It will be good in the initial 2-3 years. Afterwards, it gets into a lot of litigation and it cracks. Today, the entire surfacing proceedings are Recovery of Debt Act, all those things just stuck in court. No major realization happens. If you, I'm just giving you statistically, if you see it off, In India, it takes minimum 4 to 5 years to realize the money. If there is a default, if the company is not paying the loan, if the bank wants to realize the money by auctioning the assets, and an average it takes 4 years. That's the current story. You see, it's 4.3 years. Comparing to developed economies, which is United States takes 1.5 years, Canada takes 0.8 years, Australia takes 1 year, Singapore takes 0.8 years. And how much they realize? If they have given 100 rupees, they are realizing at least 78 rupees, 80 rupees. When they get into the recovery mode, when the loan gets default. In European Union, it all ranges between 1 to 2 years, and the recovery rates are somewhere close to 80%. Italy alone was a little bit low. Coming to emerging economies, if you see, Brazil and India, China, South Africa, Brazil and India are at 4-year range, and our recoverability is 26%. Bank had given 100 rupees loan, they are able to get back only 25 rupees. 75 rupees is lost in that one over the period timeline, and then the asset quality deteriorates and various other issues. The net realization for the bank is 25 rupees. It is again public money only. And what happens? The end result is bank will increase the interest rate from the public. They will reduce the FD rate, they will increase the interest rate, they will compensate with this cap. All these laws are again funded from the public deposits only. So this is a big anomaly for the country, and our ease of doing business in India is very poor, very low rated, because there is no way you will be able to promote the realization of the money. It is very difficult in the country. So that's why our ease of doing business rating is very poor. Post implementation of IBC and its successful driving the corporates, the ease of doing business rating has improved. That it came in media and all. So this particular factor, which takes 4 years plus for bankers and any lenders to realize the money, is a big time-killing aspect for them, and the money is going waste. It is like that. And the recoverability rate, even after 4 years, at least if you are realizing 100%, it would have been much better. But that is also not coming. Every year, 25% you are losing. In the sense, finally you are getting only 25% of it. So that's again a big disaster for any lenders in that process. So this is one of the key reasons this insolvency code in a time-bound manner have been rolled out now. I will explain how this time-bound manner in the coming slide. Just try to give you NPA statistics data in which sector more NPAs are there. Telecom and infrastructure are the highest NPA contributors. I've just mentioned about pre-IBC, before this insolvency and bankruptcy code, what are all the laws we had to deal with insolvency. For individual insolvency, okay. So prior to this insolvency and bankruptcy code, various laws were there. There individual insolvency, historically the British law is there. It is still in force even today, because the insolvency and bankruptcy code has not yet been notified for individuals. It is notified only to the extent of guarantors to corporate loans. If there is a corporate loan is there, for that if an individual has given a guarantee, then he is covered under IPC. But as an individual, you cannot invoke insolvency against him under the IPC. You have to still go back to the colonial law, provisional Towns Insolvency Act only to invoke insolvency against the individual. So more or less in another 2-3 years down the line, this individual also will be brought under that, and those two historical acts will be repealed in due course. Then Companies Act, LLP Act, SICA, the Security Companies Act, various statutes have come over the period means it's only mainly to improve the recoverability from the existing asset and to make use of those existing assets. And to some extent it contributed, but it all over a period it failed. Finally, now government has come out with insolvency and bankruptcy code. This particular insolvency and bankruptcy code, why government is very confident of pushing it is, this is an established pattern in all the Western developed economies. There, insolvency is not spread across multiple laws. Insolvency and the loan recovery or whatever, all those are consolidated under one law, and they made it as a specialized profession. Like chartered accountants, like company secretaries, like lawyers, insolvency is a separate profession in Western developed economy. Now this government wants to bring that separate profession in the country. They enacted the law, but who are the professionals to handle? Nobody is there. Then law is enacted, but there is no trained workforce to do it off. So first round, for 6 months they gave one window. Whichever profession, chartered accountant, lawyer, company secretary, cost accountant, if you had 15 years experience in the practice, you come and register. No exam, nothing. Straight away taken, practice insolvency. So because they have to have some insolvency professional to start the work. They thought, okay, 15-year experienced people, they will understand the law and they will start implementing it out. 6 months they had given a window for them to register without writing exam. There are people who with 15 years experience taken up cases and they did. During the progress, they subsequently qualified. Yeah, somewhere around 3-4 months after the commencement of the act, they launched the limited insolvency examination. So it will be LIE, they used to say, it's a limited insolvency examination. There is a national insolvency examination is in pipeline. Still now that is not notified. That is where they wanted to make insolvency as a dedicated profession. When the national insolvency exam comes, like UPSC, you will write national insolvency exam, you will qualify and you will become a professional in that. Today they are wanted to test it with established professions who have good expertise on the industry. Then they will be training up the people's workforce also will be there. Today, if I open an office, am I audible?
No.
Okay. Today, even if I go and start an office of insolvency, I may not get a trained workforce because all those people. So I will always get only fresh graduates or any people, but who doesn't have any idea of insolvency. It's a law which has not existed earlier. It's codified law. So what they have done is, first that 15-year criteria they had, then they lowered it to 10-year criteria, and they brought in this limited insolvency examination. So chartered accountants, company secretaries, cost accountants, lawyers, and they included management experienced people who worked in any of the management roles with 15 years experience. They are also eligible to get into insolvency profession. So all these 4 professionals in the management cadre, 5 category of people are allowed to write the limited insolvency examination. It's a 90. Am I audible? Yes. Okay. So this it's a 90 questions limited insolvency examination. It's a 2-hour exam, and it's a multiple choice. You don't want to do anything. You have to sit in computer only. You have to choose A, B, C, D kind of thing. In 2 hours you have to complete. In the 2 hours you have to answer all the 90 questions. You have to score 60 marks to pass the exam. If you are wrong for any of the questions, 25% negative marking. So 2 mark question, 0.5 will be lost. If 1 mark question, 0.25 will be lost. So that's a pattern they conduct the exam, and end of the exam when you finish the last question and you click submit, it lasts. Are you sure? You click yes, your pass or fail will be declared then and there. You don't want to wait. It's the control, the computer center you will go. There are centers where you will go and just appear for the exam. 1,500 rupees is the fees to appear. That's the thing. Up to now and up to another 3 months, you can write exam morning once, afternoon once, tomorrow once, day after tomorrow once. Yesterday, IBBI has come out with a notification that you can write exam once and you have to wait 2 months. And that will come into picture 3 months down the line. Say if you are in June, so from September onwards, you can appear for the exam once and you have to wait for 2 months. Up to September, you can appear every day, depending upon the slots available in that particular center. That's but that limited insolvency examination is now eligible only for your seniors, all those professionals, because they have 10 years experience. You students, since you don't have 10 years experience, either you have to go through the graduate insolvency program. After completing your law profession, you will be enrolling with the graduate insolvency program. It's a 2-year course, 1 year classroom study, and 1 year you have to work under an insolvency professional to understand the nuances of the law and how it is practiced, and then you will be eligible for writing the limited insolvency examination. So that's the pattern. So immediately in these 3 months you will not be able to write that particular limited insolvency exam, but you have an opportunity to come into this practice provided you join graduate insolvency program. This graduate insolvency program, 2 institutions are now authorized. One is Indian Institute of Corporate Affairs in Delhi. They have already conducted one batch, completed 2-year batch, finished 1921, and recently they have approved for the National Law University Bhopal. So their first batch is commencing from July. They are actually actively searching for institutions to conduct this graduate insolvency program. They have various criteria to select the institutions to do it. There should be locally many practicing insolvency professionals to come and take practical sessions in that. Some criteria they have it. Even your law college also can evaluate. You can interact with IBPA. If you are fitting in for it, it can be done. That opportunity is there. And this particular thing is, as on today, it's an on-board program, slightly costlier program, which totally costs about 12 lakh rupees for the 2 years. But all are getting placed immediately. At an equivalent salary cost to the company, they get placed. Because there is demand is very high in the industry. The kind of means the assets are the companies which are coming into the insolvency, and the thing it is managed by the professionals. Today there is no trained workforce available. So bigger institutions are ready to absorb qualified insolvency GIP students. The students, 1 year classroom, they are theoretically very strong. 1 year practical with an insolvency professional. So practical things also they are very accustomed to. So the agencies or the practitioners are ready to grab them. So, say for example, if you would have invested 6 lakhs per year, so getting a CTC of 12 lakh per annum will not be a tougher thing in this particular.
So what sort of positions you will be holding in the company once you pass GIP?
No, you have to go with practitioners.
Will you be absorbed by the company, or will you be appointed by the NCLT as a?
You will be observed by insolvency professionals practicing in the profession. See, if you have good contacts and if you are able to practice yourself, you can open up your own office, or you can join as juniors with some practicing insolvency professionals. So you have the opportunity to do that.
So you are not being appointed in company. You are not being absorbed in a company, right?
No, company is running company.
Oh,
You will not be required.
They don't
This is
require
the company
insolvency.
which got into stress only, they require it. So that's the thing. So I'll take you through the things.
So who will be appointing the IPs when there is a
Problem. Yeah, I'll take you through that. It is maybe I'll straight away jump into that places. So legal framework, IBC has elected from Parliament in May 16, and all those procedural things. Okay, changes after the legislation, the preamble of the law, Prabhu have already told it. The ecosystem, IBC ecosystem, how it is. There are 6 institutions involved in this process. The first one is the Insolvency and Bankruptcy Board of India. This is a government designated board for managing this IBC law. This IBPA comes under the Ministry of Corporate Affairs. The chairperson is appointed by the Ministry of Corporate Affairs, and they are the statutory governing body for this entire insolvency profession. Along with insolvency profession, they have been interested with the registered valuer profession also as an interim measure, because now the government is getting ready with the registered valuer bill. So far as all the valuations are not governed by any law, whether a chartered engineer does or a chartered accountant, there is no binding law for valuation. now in the Companies Act they have brought a provision and the rules have come. The draft valuers bill already is under discussion. So once it comes, the valuation board also will get created. But during insolvency process, valuation of the asset is a very crucial point. You are going to dispose it of the asset, but at what value? Who will certify the value? It is not that insolvency professional is expert in determining the value of that particular asset or business in the given context. So somebody has to certify with authority. So there is a registered valuer profession. Currently, this particular registered valuer profession is also regulated by IBPA. Sooner or later, maximum another 3 years.
Who can act as a registered valuer?
For plant and machinery, an engineer qualified in mechanical or related field with 5-year experience, he has to write an exam. And civil engineer with 5-year experience, he can write and qualify as a land and building valuer. See, there are 3 categories of that: land and building, plant and machinery, financial assets. So financial assets, chartered accountant, company secretary, cost accountant with 5 years experience, they can write the exam. Once you qualify the exam, you can become a registered valuer, registered with IBPA. So this is the current regulation prevails. So once the law pertaining to valuation gets enacted, so there will be a separate board and separate regulations will come into picture. Today it is all regulated under the Companies Act section 247. The only section which recognizes valuers as a registered profession in that. The second authority other than the IBPA from government side is the judicial wing, adjudicating authority, which is an independent wing. Today, where all the matters, whatever comes under insolvency, is all dealt by the adjudicating authority. The 2 adjudicating authorities are National Company Law Tribunal and Debt Recovery Tribunal. So, National Company Law Tribunal is for all corporate matters. Companies means private limited company, public limited company, and limited liability partnership, LLP. So, these 3 are the particular acts which come under the NCLT regulated mechanism. Individuals, partnership act, trust, and all these other things will come under the Debt Recovery Tribunal, DRT, which is established under the RDDBF Act. So these 2 are the adjudicating authorities, and both of them have their own appellate tribunals. NCLAT is there, DRAT is there, and after this, if there is a question of law, you have to straight away go to Supreme Court. There is no intermediary High Court in this. So it's either NCLT or DRT, immediate appellate tribunal, where all your appeals are dealt. If it's a question of law, you can go to Supreme Court. So that's how this appellate mechanism in this particular law. Here there is no question of civil courts or high court interventions. But still, people are intervening in form of writ petitions. Government means they just try that. Some cases they dismiss, some cases they permit. That happens in the legal system. Otherwise, adjudicating authority is at 3 levels. So that's the second leg of this particular IBC. Third is the Insolvency Professional Agency. So the IBPA is the regulatory authority on behalf of the government. But you want to enhance this profession, you have to take it to multiple people, various levels. So what they did is, instead of they themselves propagating this, they created intermediary agencies. It's called Insolvency Professional Agencies.
Is it similar to chapter for IC?
It's similar like that, but it's a Section 8 company. It's a charitable company you have to float with 10 crore capital, and there are some eligibility marks. So in this category, 3 companies have formed. One was formed by Company Secretary Institute, another was formed by Chartered Accountant Institute, and third was formed by Cost Accountant Institute. The Bar Council have never formed it up. So all those lawyer members who wanted to qualify, they are members of any of these 3 institutes. For some reason, I don't know, Bar Council have never formed this particular institute. So there are today 3 professional agencies are there. You will be a member in that agency. That agency will develop the profession. They will conduct training programs, They will conduct all the classes, have sub-chapters everywhere to have the continuation professional educational training program, all those things. We will have membership of this one IPA and then we will have membership of IBPA. So IBPA is the final regulatory authority. So this Insolvency Professional Agency is a intermediary body which develops this profession. So we are members of Chartered Accountants which develop the insolvency profession, and today we are here on behalf of that in IPA only. Because the IBPA have told all the agencies to go and spread this thing. So on behalf of IIT ICA, we are here. It's Indian Institute of Insolvency Professionals of ICA. It's a very big name. We short form IIIPA ICA. So on behalf of, we are here. So this is the third leg in this particular ecosystem. Fourth is the insolvency professional, who is the real man on the field. Success or failure, it all depends on him. You have an opportunity here to become an insolvency professional or legal counsel for the insolvency professional. You can be a lawyer, corporate lawyer dealing with insolvency. You can appear in NCLT, or you can appear in NCLAT, or you can appear in Supreme Court also. Even when I started my practice, 1.5 years, I went to court. I appeared myself. For 10 minutes hearing, I have to travel from Coimbatore to Chennai, whole day goes waste. And even the 10 minutes also, case adjourned to next day. This is the only way judge pronounces. Further, the whole day goes waste. It was decided we will never appear before court. There is a profession of lawyers that all cases assigned to them. So today I handle about 20 insolvency cases. For me, 3 counsels are there who are specialized in insolvency only. They were originally corporate law practitioners, but today, than the corporate law, the insolvency law is having more number of cases and opportunities for it. So they got into this, they are practicing it.
So once you are appointed as an insolvency professional, will you be able to delegate your authority to a lawyer unless and until he becomes an insolvency professional?
I am not delegating. I am just giving wakalat to appear for me there in the court. Because he is a specialized profession. So judges listen from them because they are authorized to do that. They are just authorized representative for me in the court. So if you are practicing corporate law, you have opportunity to represent insolvency profession in the court of law.
No, I'm asking you, once you are an insolvency professional, you are being appointed by the NCLT, right? So you should always be there at the court when the court summons you, right? So you cannot.
Perfect. I am a court officer. If you are appointed by the court, you are a court officer.
So can you authorize anyone to act on behalf of you?
See, I have been given a company in charge. The company is running. Will I sit in the company and manage, or will I appear in the court?
Yeah. Oh, in that scenario.
In that scenario, I have to sit in the company to manage the current issues, whatever it is. I have to manage it all. So I will appoint authorized representatives, generally lawyers, to do that thing.
Yeah.
So when we handle multiple cases, so the case will get published in the evening only. The court will be somewhere. And
so that is permitted and
that is permitted. Today, among the corporate lawyers, insolvency practice is the most flourishing one. If the corporate lawyer was originally making 1 or 2 lakhs per month earlier, he will be making 4 or 5 lakhs per month now.
Just because of you guys, right?
Not because of me, just because of IDBA and the insolvency procedure. I am also making money. I might have made 1 or 2 lakhs earlier, I think, and that also would have got doubled now. Because obviously, anywhere, new profession coming, when you get into any new profession, you have a first mover advantage. You will be able to capitalize the things. Over a period, things gets, competition comes in, and a level playing field, you have to reduce your fees. In initial days, you will dictate the fees. And when you enter in the first 10 years of any profession, and if you are able to establish your capability and your knowledge, and if you demonstrate it up, you can be unmatched. And you know, as a legal professional, how a junior lawyer earns, how a designated senior counsel earns per hour, per hearing. That's the difference you will have. The early entrant and a late entrant. That's that. So obviously it's hardly 4-5 years old, this one. Still, major portion of the act, which is individuals and partnership firms, are yet to be notified. After all, only 11 lakh companies are registered in India. But 130 crore individuals are there. At least 2-3 crore partnership firms are there in picture. Everybody gets into one or the other form of stress. So the opportunity to handle the insolvency matters of partnership firms as individuals are huge. Today, yes ma'am.
So you have presently told about this, sir, that there are councils who are appearing on behalf of you. So is that procedure, this examination applicable for them too?
No. Nothing. They are appearing because they are qualified lawyers and bar council members. That's all. They are representing legal profession, not insolvency profession. So insolvency profession, I only have to stand. Sometimes judges ask the insolvency professional to be present in next hearing. They give a notice. So next hearing you have to be there. For various reasons, they will call for it. Sometimes when other party asks for, they will say, I have already given him a job in the plant. He will stand there. He can't come here. Like the judge himself will tell to the other party. It's all judges will decide upon the scenario. So the fourth leg is insolvency profession, and you have opportunity to become an insolvency profession in the coming years, or represent legally for an insolvency professional before the adjudicating authorities. The fifth leg is information utility. This is it's nothing but a repository of data, other debt-related data. See, the insolvency point comes when a scenario of debt and default. If there is a debt, there is no question of insolvency. So long as it is.
Sir, what is the difference between insolvency and bankruptcy?
I will give you that. I will tell you. I will come to that next. When there is a debt, obviously everybody has debt, whether from home, via housing loans, or it's a business loan, car loan, there is a debt. Insolvency doesn't come in there. There is a default. You don't pay. Bank will send you a notice. 1 time, 3 times. 90 days criteria is that bankers follow. Then they classify it as a NPA, non-performing asset. That means that asset doesn't generate income for the bank. So they categorize it as an NPA. So that is the biggest newspaper you would have seen, so much big NPAs in the nationalized banks and all those things. Nothing but for more than 90 days they defaulted, they are not servicing the interest, they are not repaying it off. The default comes. When the debt and default is there, the scenario of insolvency comes, you can go and initiate insolvency against that company. The law asks to come and initiate insolvency at the earliest point. Don't come to initiate insolvency at the fag end. In the sense, today the loan has been taken and repayment is going. For 90 days it's not repaid, it becomes a big default. That means the company is in a big stress, cash flow crunch. If they are initiating insolvency against them and some corrective actions are taken by resolution professional, your recoverability will be better. Because when the company is working, at that time you will be able to sell it for a better price.
So, which means that that would render SURFACE useless, right?
Gradually it will render SURFACE useless. SURFACE the objective is to only take and sell. There is no business attached to it. They are not bothered about whether business continues or not. Here, the first intention is to ensure that business continues. If it is continuing, it has to continue. Only thing is, from the owner, it is taken and it is given to the creditors committee. The lenders committee will be there. Under him, the insolvency professional is there. He will be managing it out. And within a 180 days time frame, he has to identify a buyer.
But unlike IBC, if you go for SURFACE, means you can directly approach the bank and directly approach the borrower's property. He can seize the property directly without approaching the court, right?
Yeah,
when
you
it
don't
comes
get
to
SURFACE, you don't even want to go to court.
Yeah,
you issue a 32 notice, take the property.
That gives an advantage. That gives an advantage to the bank, right? That gives an advantage to the bank. But when it comes to IBC, means you have to approach the court. Then you have to start the insolvency proceedings. So this is a time-consuming process. You have to wait for 270 days, right?
You are right.
Yeah.
But SURFACE, if it's an idle asset, you can easily do it up.
Yeah.
If it's a running company, you can't take possession. If it's a working company, whether bank will be ready to take and run that company. Bank cannot go and stop it. Of 100 employees are working, bank can't go and stop it. So bank cannot take and run that company. And once they
For
take,
that, see, as per SARFAESI Act, we have got securitization and reconstruction. So there is a provision called reconstruction, which means that you can take over the assets of the company and you can appoint a person who will manage the company, right?
see who will manage, how it will be managed, and there is a provision
have-
under DRT, they can go and appeal, they can stall the entire process. All SARFAESI cases are pending before DRT. Many banks are unable to sell, although they have taken possession right from issue of notice to taking physical possession, symbolic possession. Everything is challenged in DRT and it is dragging for ages. That is why 4.3 years it takes for the bank to realize. If the SARFAESI was very strong and implementable without any problem, they would have realized in 3 months, 6 months. The disputes are dragging for 4+ years and that's why average is 4.3 years. Not that. But in insolvency, that opportunity is less of contesting and dragging that matter. A scenario today, we don't know how the law evolves. More and more of judgments, contradicting judgments, then obviously people will try to drag the matter based on those judgments.
As you said, SARFAESI would gradually become useless, right?
It will go.
So, but
Anyway, it will
gradually,
repeat.
I feel that in spite of saying this, IBC may also consign to flames because I feel so because we have got many institutions emerging. It's coming up like you have got ARCs, we have got many securitization companies, we have got bad banks as introduced by Finance Minister last year. Then we have got SPACs. Special purpose acquisition companies are coming up. They'll be taken over
I
the
tell you,
companies.
all of this will use this IBC as a mechanism for their better functioning. That you know. So information utility is a repository where all the bankers will be furnishing their regular dues and overdues and defaults of all the loans, whatever they are given. It is another form of CIBIL. In CIBIL, only the bankers give the data, whereas in information utility, all the lenders, all the creditors, all the banks, everybody will furnish the data and the debt and default data will be available at a centralized place. See now the NESL, there is only one utility has been notified and everybody are filing the details. It's a process, it takes some years for the data to build up in that thing. So that is the fifth leg. And the sixth leg is the registered valuer organization, RVO. Because IBPI has been entrusted with another duty of regulating the registered valuer, just like IPAs. For valuation also there are intermediary agencies. It's called registered valuers organization, wherein first you will become a member in RVO and then you will become IBPI.
Some insurance company brought in under RV because they have been doing actuarial services, right?
So that is altogether different story.
Yeah.
It's a different, no way related to insolvency. Okay, so we are getting into the judicial thing. As of now, the number of benches, I think, about 26 NCLT benches are there, and one single member bench at Amravati and one principal bench at New Delhi. This is the current strength of the NCLT across India, and NCLAT is the National Company Law Appellate Tribunal. Primarily they used to sit in Delhi, so there is another sitting has been started from last year from Chennai for all the south-based litigations.
So you have got a bench in Kochi as well.
Yeah, you have a bench in Kochi, so Bora is the bench.
Last year, right?
Yeah.
Last year.
Yeah, it has been started in 2019.
2009.
2019 and Kochi bench has started. So originally it was sitting with single member bench. Now it is a division bench, judicial member and a technical member also are sitting there. So this is a bench constitution as of now. And I just gave you some statistical data, I think for young people it may not be visible here. So about 4,044 insolvency professionals are registered as on 31st March. That's published data. So afterwards also people are enrolling. So it should be 4,500 something right now. Otherwise 4,044 members are registered insolvency professionals, and among them only 2,400 have taken authorization for assignment. Like even if you have a chartered accountant or a company secretary, your membership, you have to have a certificate of practice. I am a member, but I am not allowed to practice unless I satisfy some next level criteria. That I have to have a certificate of practice, I have to undergo continuous professional education training every year, 20 hours, 30 hours, there are criteria are there. So you have to keep on every year satisfied to retain your COP. Same way, there is a criteria of authorization for assignment. So that again there are also 20 hours of mandatory training you have to undergo every year if you want to retain your certificate. So the 1 year valid certificate they give. So as of now 2473 valid AFAs are there as on 31st March. So that's the statistical scenario of number of insolvency professionals. To the best of my knowledge, the requirement once individuals get notified should be 25,000 plus. Minimum will be the requirement once the individual insolvency starts. You would have seen in the newspaper auction of this property, auction of this property. Whichever newspaper you turn every day, you will find in one of the corners some property, some house, some factory, something is auctioned. In all papers it will be there. There are some designated paper, if you open, majority will be only auctions. All those are big cases for this insolvency. Will over a period everything will come in the process of insolvency. Today under SARFAESI law, under the recovery of debt, that all the other laws they are doing it up. Over the period it all will merge into this insolvency process. Once the debt. Okay, so of that 4044 thing, how many are from Chartered Accountant Institute IPA? There are 3 IPAs and their age groups. If you see less than 30, who are all the graduate insolvency program pass out guys have registered as 7 people have registered. Between 30 to 40, the major chunk lies in 40 to 50 year age groups. Even I am falling in that age group only. So in that age group only there are many insolvency practitioners are there. You are not eligible to practice after the age of 70. There is a age bar. If you are insolvency professional, you will not be given AFA to practice after 70. For some reasons they have put that age bar. That has been contested the way of it in the court, but courts also have agreed to 70 years age bar. After 70 also members are there, but they don't hold AFA. Yeah, at the age of 70, they have taken a case, and if the case runs for 3 years, they can continue to run the case, but they will not get AFA to do that. So this is a statistical data of profile of these IPs. Now coming into insolvency and bankruptcy court, I am sorry for having a wrong choice of colors. The presentation in the hall, the color choice is wrong, and let me next time I will correct it now. This particular act, Insolvency and Bankruptcy Code, consists of 282 sections. Originally, this has been enacted with 262 sections. In the last 4 years, the maximum amendments happened in this act only. Generally, the highest number of amendments happens only in Income Tax Act and the Tax Recovery Act. Every year, Finance Act passes some or other amendment. Other than that, no act will have a repetitive amendment. In this act alone, every year 2 amendments will come. Because it's highly challenged in the courts, and that too still now individual is not notified. For corporates, which is dealt from section number 5 to section number 77A, this is the relevant section. In that itself, so many amendments have come. Because they wanted to, in the one case, if the government uses, they try to standardize and correct it. So many things have happened. About 20 sections newly added. Many amendments have come in. A, B, C, D and all the section additions have come. So today it stands with 282 sections, and this particular law has amended 11 laws. So they have repealed some of the acts. They have made some of the sections in Companies Act inoperative. So some sections of SARFAESI, some sections of the customs law, they have made inoperative. So all those particular sections where the recoveries are done, they have to mandatorily come to insolvency and bankruptcy court. So this is how the law has been enacted, and last amendment was in 4/4/21. And now in this session they are rolling out another bill. It's ready for tabling for further amendments in the process. So key milestones, if you see, May 2016, the law has been enacted. From December 2016, the law has been notified for practice for corporate persons alone. In 2016, only corporates, private limited company, public limited company, LLPs are notified for IBC. Then in 2019, the guarantors for corporate loans, if it's a partnership firm or individual, they are covered, provided they are given guarantee for a loan of a company. If they are not given a guarantee, they are individual lender, then they are still not covered. They have to go to provincial insolvency laws. If they have given a loan or guarantee to a private limited company, then as of now they are notified to undergo IBC process. So it applies to whole of India. Originally Jammu and Kashmir was not covered. After the Jammu and Kashmir Integration Act, this also has been made applicable to Jammu and Kashmir. And I just tried to make a pyramid of opportunity available in various areas. If you see bottom of the pyramid, it is partnership firm, proprietors and individuals, where large number of cases are available, potentially available. Once it comes, you have an opportunity of taking the insolvency profession or practicing legal matter for all those individual partnership firm in the DRT. See, DRT is there at various district levels. Only if you want NCLT, it is always under the state headquarters. For NCLT, you have to go to Kochi. But DRT, at least 3-4 DRTs will be spread across Kerala.
You are having only one.
Here it is only one. Oh,
Only in
Tamil
Kochi.
Nadu we have 3. Here it's only one. So you will have a DRT practice, wherein you can represent for individuals, partnership firms, not the corporates. Or anything. Next is that Companies Act, whatever companies. So the companies are limited, registered enterprises. Whereas individuals are enormous opportunities. So just try to make an opportunity pyramid. And okay, so this all I had given you a very brief about the entire insolvency thing. So another 20-30 minutes I will take you through the law. How, in what are the methods the insolvency kickstarts, how it is managed by insolvency professional, how it comes to a legal closure for the entity and for the individual. Here, if it's a corporate, it is insolvency kickstarts. When the company is not able to pay the debt, it becomes insolvent. And when there is no solution or no takers for the company, then court orders for liquidation. Liquidation is nothing but sale of assets. We strip the company, sell the asset. Machinery taken, sell separate, building separate, vehicles separate, all. During the insolvency process, the RP will call for a public announcement and he will call for interested buyers to take over the company. Company as a whole. When it is not viable, it gets into liquidation. When it comes to individual, nobody else can come and take over. See, if it's a company, you can ask this management person to go out and somebody can come sit and manage. Because that's an artificial person. An individual, an outsider cannot come and solve your problem. See, you are dead and nobody can take over you. Correct? So you have to give a repayment plan. In insolvency of a corporate, it is called resolution process and resolution plan. Whereas in individual, it is called repayment plan. You may have 100 crore or 500 crore debt. The biggest debt today in the public media is Anil Ambani, who has been brought under the insolvency. So he has challenged in the courts. Finally, courts also dismiss it. He is undergoing the personal insolvency. Now, you have to give a plan that I have 500 crore debt or 1000 crore debt. But in another 3 years time, all these assets I will sell off and I will give you 10% to all of you. I will be able to generate 100 crore and I will pay all of you 10%.
What purpose would it serve? See, for example, an individual becomes bankrupt or insolvent when he is unable to pay off his debt. The lender have got two choices. Either he can invoke SURFACE or IBC, right? So when it comes to individual, the lender would normally be invoking the SURFACE Act
But,
because the
no,
individual must have property.
Fully, no?
The individual must have property,
Correct.
right? When it comes to IBC, if he doesn't have the property, what's going to happen? Like how he will make repayment?
Correct.
Yeah.
Do you think that everybody has security to if somebody gives money to you?
May or may not have.
Yeah, then may not people will do what?
Yeah, yeah.
See, bank takes some security. They are giving you car loan. They will come and take your car if you don't pay the loans.
Yeah.
Bank gives housing loan. If they don't pay, they will take and sell the house. That's very few. In an individual life, you will get this kind of structured loans, one or two. But you will take so many loans from many people, no security. You will give check as a security. Nothing, no money
But
is
you
there
can
in
put him
it.
in jail. You can put him in jail, right? When it
By
comes
by putting him in jail, what the lender gets?
nothing.
No, we wanted to recover something. See, finally, how much year you can put? 2 years, 1 year, 5 years, he will come out.
And the expenses of the same has to be borne by the lender itself.
The problem, why that should be there? On the other side, all these lending, all these borrowers, no, you will see in everyday newspaper some family committing full suicide. It's a sad part because of debt. Some social problem, they don't want to face it, they commit suicide. Because in India, this insolvency is always seen as a social stigma. If you are an insolvent, your generations are told that your father had given yellow notice. He was insolvent. Your grandfather had given insolvent. This is a problem. Because historically, this was a social stigma. But this is not the case in Western countries. The previous US President Donald Trump and his company thrice had given insolvency. 3 times his company has been declared insolvent. He became president of the country. How can an insolvent becoming a president? Because their insolvency is a structured law. Corporate insolvency is separate, individual is separate. Even if individual is insolvent, there is an individual insolvency process timeline. Once it is over, you are free. You are not disturbed for your old debts. If I am say for example, let me take me as an example. If I have 10 crore, I have to repay. I have only 1 crore worth of assets. People, whoever secured lender, bank takes and sells it. Okay. Balance 9 crore guys will go and put case against me. It can go to court. I will go and file insolvency notice. See, this is the wealth I have. How much? And I can maximum
How
pay
will you
this.
realize assets unless and until this person has got assets?
It is not there, not realized. There is a court will appoint a bankruptcy trustee.
Bankruptcy
Trustee. See, insolvency process, he will give a repayment plan. If it is acceptable to all lenders, he will say, see, I have 10 crores, but in next 3 years I can earn 2 crores. So in next 3 years I will repay 20% to all of you. Are you okay with this? He will give a plan. Whether lenders can accept or not, it is their choice.
If it's not acceptable,
If it is not acceptable, the insolvency process fails. The case gets into bankruptcy. So bankruptcy court appoints a bankruptcy trustee. Bankruptcy trustee is an insolvency professional like me. What he does is he comes, he takes over your all the assets. All the assets including your house, your jewelry, your car, everything.
you have nothing.
You are nothing. There are 4 exceptions are given in that. One, residential house, which is less than 20 lakhs value. Some religious sentiment related jewelry, Mangal Sutra, all those assets. Some books and trade specialized tools, which is required for your survival. Some of the tools you may repair. The carpenter repairs that hammer and those
Sir,
things.
I have nothing.
You have nothing,
My
anything
assets have
ever.
been taken over by the bank. Still, I have to pay.
Yeah, that's all. See, in bankruptcy, the period is 1 year. Once the court orders bankruptcy, bankruptcy trustee is nominated. He takes complete control of your assets. And for next 1 year, you are under his control. You can't make anything. You can't be appointed in any government roles. You can't even.
So So you have to remain jobless till the
Not jobless,
till
you
the
will
last month,
work.
right?
You will work.
You have to
Whatever you earn, more than your basic necessity, it will come to the bankruptcy court. If you are earning 1 crore, if your family requires only 50,000 or 1 lakh to survive, balance money come to bankruptcy court. And it will be distributed to all the parties.
Which
That
means
period
that
is
you will
1
be
year.
literally under the scanner of this bankruptcy trust.
100%. You will be under the scanner of the bankruptcy trustee and the bankruptcy committee will be there. You will be under their scanner. You will not be able to allow travel abroad without court's permission. All those restrictions will be there. You are ineligible under all the laws in the country. If you have read any laws, for example, you would have read Contract Act, you would have read People's Representation Act. Everywhere in the eligibility they would have written, you are declared undischarged insolvent. Right? That one word is there, undischarged insolvent. It is nothing but this 1 year period. You are undischarged insolvent during this 1 year period, where the bankruptcy kickstarts and 12 months. End of 12 months, whether or not liability is settled, whether or not assets are sold and distributed, bankruptcy trustee will continue. He will sell and distribute, but you are discharged. You are not responsible for the old debts anymore. You are discharged. So that 1 year is a undischarged insolvent period, wherein almost all acts in India disqualify you during that period. So that particular provision was there in the Provincial Insolvency Act itself. So the same thing continues here. So you can't contest in elections. You apply for any registration license, everywhere you will have rejected them. So that is the thing. So that 1 year is the bankruptcy period. So insolvency is where you will give a plan, acceptance and all possibility that fails. Court will order bankruptcy and you have to, it is literally a honeymoon period only. You can't do anything, nothing, nobody else can do anything on you. Nobody can sue you, you also cannot sue anybody. No recovery possible. You work for your earnings, your living, any surplus comes, go to the liquidation estate, it will be distributed. End of 1 year you are discharged. But there, what debts are discharged, what are not discharged, there are some segregations. Any criminal penalty, if levied by the court of law, those are all not discharged. Only debts, contractual debts you have taken and you are indebted for, those are discharged. But because of your illegal practice, you have been fined by the court for something that you are still liable for it up. If that law says that if you don't pay, you have to go for imprisonment, you have to go for it. Before bankruptcy, you would have been ordered for that. You can't come and claim, no, I am an undischarged insolvent, now discharged. So that liability is not continuing.
So it means that you will not be let free unless and until you fully pay the last penny to the creditor.
Not to the creditor.
I mean, to the bankruptcy.
No. For criminal proceeding penalties are all. That is not for the debt related. Debt related will go on. You committed some offence. For that court levied, traffic offence, 500 rupees levied, you have to pay. You don't have a charge. That's the thing. So those specific things alone you are not discharged. That will continue. That's it. So
after this 1 year period, for example, after this 1 year period, I will get discharged. And tomorrow, I go and buy some property. Can they recover it from me?
no, you go. No. Then it is.
Big value.
If it's a big value, you have to prove your source of money.
For example, I got the lottery.
And then no. Any income you generate after that will not be covered. But you have hidden some assets, old assets. You have not disclosed it earlier. That is supposed to go to the creditor. You hidden. Today it comes to you. It will be taken.
After the period, whatever I get, that's for you.
Yes.
I cannot claim on you.
So the interesting thing we came to know when we met one more practitioner in Kerala. In Australia, in 3 years, one person has given 3 times insolvency. He gave insolvency, he waited for the period, again he borrowed something, again he gave insolvency. In 3 years, he had, not 3 years, sorry, 10 years, he gave 3 times insolvency. Then it becomes a regular process. For them, they borrow, they live in debt, they are not able to generate money, they go and give insolvency. After 1 year, this kind of wait period, they get discharged. And then further again, they will fail up living. One day they go in the again bankrupt. So we had seen a scenario, 10 years we get rise bankrupt.
These banks, they will give like loan again for this interest
It is it.
provided. He might be blacklisted.
No, you see, they give based on some income levels. He will be in some job. Based on it, they will not give multiple crores. They will give few lakhs. They will take this bankers. So it's not one bank. He will borrow from 10 people. He will go bankrupt because of all the 10 pressures. So that person. Yes, ma'am.
So that writing of the asset, is the intention of that person being could be something which is happening occasionally also. So whether the intention of this that the
Whether his intention is to hide or not, once it comes to light, it will come to the pool. He has to. Somebody is intentionally doing it, he can be punished under the law. If the particular person, individual is intentionally hiding the thing, the law provides for imprisonment also. The law has the powers to do that. Right? So this is a brief about the thing. I'll just another 15 minutes, I'll just glance through the basic procedures in the thing. When it comes to corporate, 3 people can file the insolvency petition. 1, financial lender, bank or somebody who had given loan, he can file. 2nd, operational creditor, he doesn't have given loan, but he would have given goods and services. An employee would have given service, supplier, all those people can file. So they are 2nd category. 3rd category, companies themselves can file. Companies themselves say we are not able to repay it up. So there are 3 scenarios, 3 kind of people can file, and the court can admit it or court can reject. So there is a time.
Why does company take such a drastic step when you have got a voluntary winding up system?
No, but see, voluntary winding up is a scenario when you are solvent. In the sense, you have assets enough to repay all the loans.
So the intention of the company is for resolution rather than liquidation. Why
Yeah. See, they wanted under the law some coverage, somebody can come and take over, some deductions from the debtors and all can happen.
Yeah.
So they go and file it. Before completely going bankrupt, they go through insolvency process and they try to revive it. If not by themselves, somebody else can come and revive it under the authority of law.
So what is the position if the company, corporate company, is insolvent here and they have some property outside India?
It will be under the, if it is a registered company in India and if the property is an Indian company name, the insolvency professional will control. Subsidiary company will not come. Subsidiary company, the shares of the subsidiary company is the asset of this company. So what the insolvency professional will do is, he will sell the shares. Because it's a different legal entity. He is not empowered to deal with it. For him, the share certificate is asset. He will dispose it. That's it. Thank you. Right. So this is the timeline. 180 days, how this entire thing has to go. First case gets submitted in the first 14 days. The law says it has to be admitted or dismissed within 14 days. But in practice, it may take up to 30 days, 60 days, 90 days, because they file counter and all those things. Then from there, 5 days, we have to make a public announcement in the newspaper that the company has become insolvent. You have to submit your claim. Then based on the claim, we will constitute a committee. By 30th day, we have to conduct the committee of creditors meeting, where all these lenders will sit there. And from there on, we will be taking up the resolution process. We will publicize invitation for expression of interest, and based on the expression of interest, we will give request for resolution plan. Based on that, people will submit the plan. The plan will be evaluated by the committee. The committee approves. The committee has to approve in the 180 days period. Once the committee approves the plan, it will be submitted to adjudicating authority for approval. Adjudicating authority is NCLT. Once they approve the plan gets implemented. He will say in 3 months I will pay the money, 6 months I will pay the money. So that's the implementation period. At the end of the implementation period, the company as a whole goes to him. All the old debts gets written off. He would have paid 10 crore. In the 10 crore, all these people will be paid as per the approved plan. The approved plan will say the lenders will be paid 40%. The operational creditors will be paid 20%. Employees will be paid 30%. Whatever has been mentioned in the plan, which is approved by the adjudicating authority, the money what is collected from them will be paid to them, and the entire debt gets discharged. He gets a clean sheet company. The person who is coming will have no debts. See, when these assets are lying idle because it has huge debt, they are not able to service the interest for it. But no company is unviable. Every company is viable at particular debt levels. See, this cannot service an interest of 10 crores, but this business can service an interest of 1 crore. Because the margin will be very low. So it can only service lower debt. So the buyer will come and say, I will see whatever be the whole investment, I don't mind. I am willing to buy it only for 2 crores. He will come and tell his price. Among the buyers, whoever offers the best price, the company will be given to them. It's an open public notice will be called for, whoever comes, it will be given to them. So they will run the enterprise successfully because for them, they are taking this company at a viable price, not with the unviable debt, which historically the old promoter would have led to the collapse.
I feel that there is an interesting interplay between contractual obligation and statutory compliance
Yes.
of two parties, that is committee of creditors and of course this resolution applicant, as you said, who have provided expression of interest. So I feel that once resolution agreement is finalized between the committee of creditors and the resolution applicant, if there is any subsequent adverse material changes happen, let's say the destruction of the subject matter of the corporate debtor, the sole property of the corporate debtor. So in that scenario, can the resolution applicant withdraw his application or withdraw his agreement or modify the agreement by submitting an application before NCLT?
Okay, this was a scenario which is coming before even Supreme Court also. I will tell you the similar scenario, but in a modified way. There is a large enterprise plan has been given, they have been approved. The plan was approved by the court also. They are about to implement, COVID came. Because of COVID, the entire thing collapsed. So the value of the asset have come down drastically. So they said, no, because of this force majeure condition, we are, the whatever price offered is no more viable for us. The matter went up to Supreme Court. Supreme Court categorically said, yes, you have done, court has approved. Binding on you, you don't have days to go back and your words. But you have to stick on.
But I personally feel that if you look at the section 60 of NCLT, NCLT is clothed with inherent jurisdiction connected to any matter rising out of resolution liquidation. So as per that jurisdiction, as per that power, definitely NCLT can withdraw or modify the application.
Yeah, but NCLT on case-to-case basis may decide, may not decide. It's not binding on the NCLT to compulsorily give the relief to it. Depending upon the scenario, they may. See, you may go, a natural calamity has come, earthquake has come, completely demolished. Obviously, NCLT will give you permission to modify it now. Really, there is no. But now COVID has come, 6 months, it's closed, value would have reduced. It may take 3 years to recover the value. Those are not exceptional scenarios in the angle of court. Court says that used to give the thing. See, in every law, court has some inherent powers inbuilt just to look into the principles of equity.
Yes.
So that is because that's an independent mechanism in our country, the legal system. So they always be having this inherent power, but to what extent they exercise is their judicial powers, their discretion, they have to do that. So that's the thing. So this is how this 180-day process it goes. By chance there is no plan, no buyers, or the plan given is rejected by the court, saying whatever the basis allocation or the amount not convincing to the court. Court has powers to reject. If it is rejected, an order for liquidation will be passed. Liquidation is nothing but stripping of the assets and selling. So a liquidator will be appointed. The same resolution professional will be appointed as a liquidator. Then he will proceed with selling of the assets individually and settling to all the parties. So the question comes here is, you are selling off the assets in the liquidation. To whom will you settle? The debt is 1,000 crores. The asset it fetches is only 100 crores. See, the asset is more so than it would not have an insolvency situation would not have come. So it has insolvency came because the asset is less. So when money realization is less, the law has prescribed a waterfall mechanism. Who has to be paid first? This particular distribution mechanism was one of the turning points for success of this law. Historically, crown dues had the priority. In the sense, whatever money due to the government, whatever income tax, whatever sales tax, customs duty, PF, ESI, whatever it is, they had the priority. This insolvency law, government foregone the priority. They had their below the secured lenders. Bankers will take their money first. Employees will take their money first. Then government will take. That's how they modified their structure. So that's one of the key points. Anybody wants to come and go in this route. If bankers go under surfacing, they have to pay the government dues. If they want to enjoy the benefit of government dues coming down, they have to compulsorily come under IBC. If they are invoking other laws, crown dues will have the priority. Under section 53, when the assets are distributed, crown dues take a lower priority. First is insolvency process cost, liquidator cost and all. Then comes workman due of 24 months salary and the security cost, whoever the security cost. Then comes employee work, first 24 months is workman due. You know the difference between the workman and the employee. So then comes employee's 12 month due. Then it comes unsecured financial creditors. So they are given loan but they don't have security. So they will get. Then comes government dues. After that, operational credit dues come. So this is the priority change, waterfall mechanism change that make this law.
So how will you prioritize payment to unsecured and secured creditors?
Depending upon the security of the asset. See, for example, you have taken a housing loan. House is there. Whatever money realized from sale of the house will go to the secured creditor. Whether it is company law or individual, wherever it is. In insolvency, this is how it is. So, whatever the asset has been given as a security, the sale realization from the asset will go as a priority payment to that lender. And if the loan is 1 crore, by selling the asset, 75 lakhs have been realized. The balance 25 will become unsecured. He has to come to the 25 will come in the fourth category. So he has to wait, some other asset sale, some money balance is that he may get. If there is no asset, he will not get it. So this is how the order of priority in the liquidation. This is the biggest change, is the government dues which have taken lesser priority comparing to all the erstwhile laws. Right? This is the key reason that bankers and all the lenders preferring to come under the IBC route rather than going under SARFAESI or any other recovery mechanism. So appeal mechanism I said NCLT, NCLAT and then Supreme Court. Supreme Court only question of law you can go for. And number of insolvency cases came in the last 5 years. Up to March 22, the statistics is about 5,258 cases have come up. And the cases at various stages, some things are on appeal, some things are withdrawn subsequently, some things are resolved, some things resulted in liquidation. This is the statistics published by RBI. And if you have read newspapers in the last 3-4 years back when this was enacted, RBI has identified 12 major accounts. In the sense, 30,000 crore loans becoming default. RBI identified 12 loans compelled the banks to go under insolvency process, the live companies. But RBI compelled them to go through insolvency process because it's already defaulted and its debt is unnecessarily growing. So out of that, 8 companies are already resolved. New owners have come and taken and standing. Still 4 companies are under some other litigation it is going. 8 companies, the owners got changed. It's all huge debts, many compromises, many haircuts have been accepted by the banks. Now finally the entire assets are fully put to use by new set of investors. So 8 accounts are there, another 4 most probably in a year or so that may also get resolved. Expectation from an IP. If an insolvency professional, what does the law expect from you? Obviously, you should have a strong knowledge in the company law. You should have strong knowledge in banking and finance because you are taken as soon as you have been appointed, you are the CEO of this enterprise. The very first day you go there, you enter as a CEO. All powers are under you. Bank account operation rights will come under you. All the top positions will report to you. Obviously, there will be a lot of reluctance from the existing management. You have to manage that and you have to take charge of it. You should have a strong knowledge on cash flow management, insolvency law, stakeholder management, negotiation skills. Name any skill there. A CEO has to possess. You have to possess. If you are becoming an insolvency professional. If you are a lawyer, then you have to present before the judge. Strategically, depending upon what the mood of the judge also, you will be offended. If you want to practice insolvency, you have to have a complete knowledge on finance, law, managerial matters, accounting, financial statements, manpower management, everything you should have skill set to handle it up. You will be the person responsible. You are allowed to take additional people for your resource. But for everything, you are one and only responsible. Insolvency professional will compulsorily be individual. They will never appoint a firm. They will never appoint a consulting firm or a company as insolvency professional. Whatever be the size of the case, only one individual will be appointed as insolvency professional. It may be that the case of 56,000 crore goose and steals. One person has been appointed, but he had a big team. He's part of the Deloitte team, so he had supported with 100 to 200 chartered accountants. Their fees per month was about 2 crores to 3 crores. They have been paid fees. They have a big team to manage the 56,000 crore debt asset. Because they have units across India, so they are responsible for it. So that opportunity is there.
We have an interesting anecdote happened in 2012, wherein a lawyer called Harish Salve represented Vodafone, who got around a remuneration of 60 crore.
Yes,
A single
that's a key judgment on the transfer pricing matter for the Vodafone. For the capital gains of Sterling.
Yeah, definitely.
Yeah. Today, you are all in law profession, you know which lawyer charges per hour,
So
per
whatever
hearing,
professions whatever be the professions, you cannot compete with lawyers because the lucrative is huge.
That's that. Okay, so these are the matters where an insolvency professional is expected to have a working knowledge on those things, on all the tax laws, on all the commercial aspects of the business. Because then only you will be able to understand the business faster. You have to take charge on day one and you have to run it. The promoter will always try to dissuade you, or he will try to throw you. He doesn't want to lose control. He will do all the drama. So you have to manage that. So the roles and responsibilities I just listed down. It will be too theoretical for me if I read it out. Whatever I told, those things are there. ARP, RP, as a liquidator, it is there. As a professional opportunity, you have various things. One, okay, this is for registered valuer, is more for class based. An engineer, a chartered accountant, a cost accountant, or they will have the thing. Forensic audit, again, this forensic is not regulated today. So even lawyers also do forensic audit to the legal aspect of the assets. Financial aspect, the financial valuers, they do it all. So forensic audit, obviously, on a legal aspect, lawyers have a good opportunity to do it. Where you have to trace the trail of ownership or the litigations you have to handle up, there is a possibility of forensic audit in there. Then representation. So representation is always a big opportunity. As lawyers, you are always representatives for one or the other matters in one or the other, either as a respondent or as an appellant, you will be in the things pleading before it. So you have a representation as a big opportunity in that particular thing. Other opportunities, they have to submit a resolution plan. That resolution plan runs into 50 pages, 100 pages. It's all legally worded, notwithstanding subject to so whatever law words you have in any act, everything will be there in that resolution plan. It's all drafted by lawyers. All the resolution plans are drafted by corporate lawyers. You have due diligence opportunities for lawyers to do it. Data processing, more kind of finance professionals do it. Managing the borrower's business. If you are insolvency professional, you have opportunity. You yourself can do, or you can have a firm where insolvency professional is there. For him, you can give always an assistance to the thing. Secretarial and legal works opportunities are there. So all these are opportunities available for the professionals in this insolvency field. Challenges, I just try to put it, small thing, obviously you have to qualify the exam, 50-hour test, 50-hour training you have to sit. You should be, in technical terms, you should be fit and proper person. That's the exact wording used in law. If you want to become an insolvency professional, you have to be a fit and proper person. So you should not have civil negative thing, you should not have defaulted anything, or no cases should be there. There are instances where some professionals have charge sheet filed against them by CBI or some courts. They said unless you get discharged, you will not be given membership. So those facts have happened. So that challenges are there. Resistance from the existing promoter to run the show. Physical threats. There are scenarios where insolvency professionals have been threatened at gunpoints. Obviously, promoters will not be liking to lose the control of the company. So there are instances, 2-3 places where insolvency professionals are kidnapped, are wrongly arrested. Various things have happened and it went to courts and good safety has been built up over the period, but again, that kind of threats are still coming up. Keeping updated on various matters, managing the business affairs on day-to-day basis. It may be a new business. You will be sitting in law practice. Yeah, I have recently taken up a hotel under my insolvency thing. It's a national brand hotel having 135 rooms. Yesterday, full day I was sitting there. There is one or the other problems are there. To manage it, you have to sit there. My profession is started accountancy. Basically, I know only accounts. But once I get into it, whichever kind of company comes, I have to learn and implement that. I have to sit there and do it all. So that you have a learning opportunity at the same time, you have to face the ground realities and challenges there. Then everything is time bound. Any complaint you take, T+3, T+6. In the sense, the day case is admitted, from there your clock runs. Third day you have to file this. 6th day you have to conduct the meeting. 7th day you have to publish. 20th day you have to do this. Like that for 180 days, the calendar is full. You have to abide by it. Otherwise, somebody will pull you to court. In this matter, in insolvency, the uniqueness is, in your normal life, whatever you do, out of 1 in 10,000 will go to court. You can do thousands of acts, thousands of papers you will sign. 1 in 1,000 or 1 in 1,000, 10,000 will go to court. But once you come into insolvency, everything will go to court. Because the paper comes to you from court. Court has appointed you. Everything is challengeable. You don't know what will be challenged. Your voice that you want to talk will be recorded and challenged in the court. Whatever written communications make will be challenged in the court. So you have to be professionally very careful in doing that. That's a big challenge you have in that. Finally, numerous stakeholders, shareholders will be there, suppliers will be there, customers will be there, bankers, everybody will be calling you. Owners will say, whenever they call the owner will say, sir, company is not my control, court has taken, this is the number of the liquidator. Even at night 7 o'clock also, one supplier will call, sir, this company has to pay me this money. When will I get? So all those things you have to bear with, you have to handle them politely, and finally compensation for all the efforts what you put. As of now, the industry is not so competitive. You are getting your professional remuneration at par with international standards. You will be able to calculate your fees on hourly basis. Some good professionals aim up to say 5 to 10,000 per hour. Some starting professionals earn up to 1,000 to 2,000 per hour. I'm just trying to average out and tell you. Somewhere even I handle it up. I do some cases billing of 10 lakh. Over a period of 4-5 months, then I sell asset, get a percentage equity. Sometimes I will not bill for months together. I will get monthly 50,000, 75,000. But on an hourly basis, for a professional, this is a highly remunerative job at current scenario because it's not overcrowded. It is not much. The cutthroat competition has not come in. In every profession, the cutthroat competition will come in over a period of time. As a lawyer, you will know. There are people who take case even for 1,000 rupees. For 10,000 rupees, 10 lakh also people take cases. It's all how you position yourself and what is the kind of competition you have. So that's the similar scenario will be there for this profession also in the long run. But in the early stage, you have a better advantage of positioning yourself and earning better. And I just had 2 slides to give you the insolvency of individual. Individual, the debt default is only 1,000 rupees. Only for corporate it is 1 crore. It's individual 1,000 rupees. And who can make either loan giver or loan taker. You are given loan. Here there is no bank, supply, replay. You are given loan, you can initiate. And I have taken loan, I am defaulting, I can initiate. So only 2 things. So this is a timeline chart. There again 180 days. In 180 days, how many days what you should do overall process. And the bankruptcy again 1 year, what has to be done. Sir, I have left this presentation with you only. Whoever is interested, if I have persuaded you for corporate law practice, you will be most welcome to do that. The corporate law is always a promising area. In the long run, large profile cases are there only in corporate law matters. You can go through this, and that's all on my side. Thank you. Available for any questions up to the time the management permits. Questions, if at all anything they have, I can answer.
Good evening. Hello, yes. Hello? Fine. അദ്ദേഹം പറഞ്ഞത് സാറ് പറഞ്ഞതിൽ ഇംഗ്ലീഷിൽ ഒരു സെഷൻ ചെയ്തു. ഞാൻ എൻ്റെതായിട്ടുള്ള ഇംഗ്ലീഷിൽ പറഞ്ഞ് കുളമാക്കുന്നില്ല. അദ്ദേഹം പറഞ്ഞത് എന്താണെന്ന് വെച്ച് കഴിഞ്ഞാൽ അതിൻ്റെ ഇമ്പോർട്ടൻസ് നിങ്ങളൊന്ന് മനസ്സിലാക്കിയാൽ മതി. അതായത് നമ്മൾ കേട്ടതിന് ശേഷം ടു ബി ഫ്രാങ്ക് എൻ്റെ ഈ പ്രൊഫഷൻ വിട്ടിട്ട് ഇതിലോട്ട് പോയാലെന്ന് ആലോചിക്കുന്നു. After all, you are working for money, right? You are working for money? Yes. 2006 മുകേഷ് അംബാനി അനിൽ അംബാനി തമ്മിലുള്ള സ്പ്ലിറ്റ് ഫാമിലി ഡിസ്പ്യൂട്ട് റിസോൾവ് ചെയ്തു. ഒരാൾക്ക് പെട്രോളിയം ബിസിനസ് കൊടുത്തു. അച്ഛൻ തുടങ്ങി വെച്ച പെട്രോളിയം ബിസിനസ് ഒരാൾ മാനേജ് ചെയ്തു. രണ്ടാമത്തെ ആൾക്ക് ടെലികമ്മ്യൂണിക്കേഷൻസ് കൊടുത്തു. അന്ന് അനിൽ അംബാനിക്ക് ടെലികമ്മ്യൂണിക്കേഷൻസ് കിട്ടി. അന്ന് അദ്ദേഹത്തിന്റെ നെറ്റ്വർത്ത് എത്രയാണെന്നറിയോ? 1991 ഒരു നാർക്കോ പാബ്ലോ എസ്കാഡോ എന്നയാളുടെ പേര്, ഞാൻ ശരിയാണെങ്കിൽ. അദ്ദേഹത്തിന്റെ നെറ്റ്വർത്ത് അന്ന് 1991 മരിക്കുമ്പോൾ $42 ബില്യൺ ആണ്. 42 മുതൽ 46 ബില്യൺ ആണ്. $1 ബില്യൺ എന്ന് പറയുമ്പോൾ നമ്മൾ ഏകദേശം 8,000 കോടി രൂപ കാൽക്കുലേറ്റ് ചെയ്യാം. ഇൻറ്റു 42 8,000 crore. ഇപ്പൊ ഏകദേശം ഇപ്പോഴത്തെ ഡോളർ വാല്യൂ നോക്കുകയാണെങ്കിൽ ഒരു ഡോളർ എന്ന് പറയുകയാണെങ്കിൽ ഏകദേശം 70-80 രൂപയെ. ഓക്കെ, 7,000 crore പഠിക്കാം. അപ്പൊ അങ്ങനെയാണെങ്കിൽ 7 into 42 crore ആയിരുന്നു അന്ന് ഒരു ഡ്രഗ് കാർട്ടലായിരുന്നുള്ള കൊളംബിയൻ പാബ്ലോയുടെ നെറ്റ്വർത്ത് എങ്കിൽ 2006 അനിൽ അംബാനിയുടെ നെറ്റ്വർത്ത് എന്ന് പറയുന്നത് ഏകദേശം $46 ബില്യൺ ആയിരുന്നു. ഇത് എന്തുകൊണ്ടാണെന്നുള്ളത് നിങ്ങളൊന്ന് ഇന്റലിജന്റ്ലി നിങ്ങളൊന്ന് അനലൈസ് ചെയ്യുക. 2006 അനിൽ അംബാനിയുടെ നെറ്റ്വർത്ത് 46 കോടിയാണ്. അന്ന് മുകേഷ് അംബാനിക്ക് ഉണ്ടായിരുന്നത് ഏകദേശം $30 ബില്യൺ താഴെയുള്ളൂ മുകേഷ് അംബാനിക്ക്. ഇന്ന് മുകേഷ് അംബാനി കുറിച്ച് പറയുകയാണെങ്കിൽ മുകേഷ് അംബാനി ഏകദേശം 90-ന് മേലെ $95 ബില്യൺ ആസ്തിയായി. അനിയനായിട്ടുള്ള അനിൽ അംബാനി കഴിഞ്ഞ ഒരു 6-7 മാസങ്ങൾക്ക് മുന്നേ പുള്ളി പറഞ്ഞത് പുള്ളിയുടെ നെറ്റ്വർക്ക് 0 എന്നാണ് പറയുന്നത്. സീറോ, അതായത് ഒന്നുമില്ല, നോ അസറ്റ്സ്, നത്തിങ്. എവിടെ കിടന്നുവെച്ചാണ് 46, ഏകദേശം 2 ലക്ഷം കോടിയുടെ അടുത്ത് ആസ്തി ഉണ്ടായിരുന്ന മനുഷ്യന് ഇപ്പൊ എന്താണ്, ഒന്നുമില്ലാതെ സീറോയിൽ നിൽക്കാണ്. എന്തുകൊണ്ട് ഞാനിത് പറഞ്ഞു എന്ന് വെച്ച് കഴിഞ്ഞാല് ഈ അനിൽ അംബാനിക്കെതിരെ എല്ലാവരും ഇൻസോൾവൻസി കേസുകൾ പല ബാങ്കുകൾ ഇനീഷ്യേറ്റ് ചെയ്തു. ഞങ്ങളുടെ പൈസ കടം കൊടുത്തത് ഞങ്ങളുടെ പൈസ തിരിച്ച് കിട്ടിയിട്ടില്ല. അപ്പോൾ അങ്ങനെ ഈ IBC ആക്ട് പ്രകാരം ഇനീഷ്യേറ്റ് ചെയ്ത സമയത്ത് നിങ്ങൾ ആലോചിക്കുക, നിങ്ങളിൽ ആരെങ്കിലും ഒരാൾ, ഇന്ത്യയിൽ ആകെ 50,000 ഇൻസോൾവൻസി പ്രൊഫഷണൽസ് ഉള്ളൂ എന്നാണ് ഇദ്ദേഹം പറഞ്ഞത്. 5,000 ഇൻസോൾവൻസി പ്രൊഫഷണൽസ് ഉള്ളൂ എന്ന് വിചാരിക്കുക. വളരെ വിരലിൽ എണ്ണാവുന്ന ഇൻസോൾവൻസി പ്രൊഫഷണൽസ്. അതിൽ ഒരാള് ഈ അംബാനിയുടെ ഈ എംപയർ മാനേജ് ചെയ്യുക എന്ന് പറഞ്ഞു കഴിഞ്ഞാൽ എന്തായിരിക്കും? പുള്ളി താമസിക്കുന്ന വീടിനുണ്ട് 4,000 കോടി രൂപയുടെ ആസ്തി. താമസിക്കുന്ന വീടുണ്ട് 4,000 കോടി. ഏട്ടൻ താമസിക്കുന്നതിന്റെ വാല്യൂ എന്ന് പറയുന്നത് 16,000 കോടിയാണ്. അതല്ല ആന്റിലി, അവിടെയല്ല. അനിയൻ താമസിക്കുന്നതിന് ഏകദേശം 4,000 കോടിയുണ്ട്. ആ ഒരു എംപയർ ഇൻസോൾവൻസി ഇനീഷ്യേറ്റീവ് എടുത്തിരിക്കുകയാണ്, ഇനീഷ്യേഷൻസ് എടുത്തേക്കാണ്. അത് നിങ്ങൾ എന്ത് ചെയ്യാക്കാണ്? നിങ്ങൾ അത് മാനേജ് ചെയ്യാൻ പോവാണ് ആസ് ഇൻസോൾവൻസി പ്രൊഫഷണൽ. സാർ പറഞ്ഞ അനുസരിച്ചിട്ടാണെന്നുണ്ടെങ്കിൽ നിങ്ങൾക്ക് എത്ര രൂപ കിട്ടാൻ പോകുന്നത് പെർസെന്റേജ് റേറ്റിലാണ് നിങ്ങൾക്ക് കിട്ടാൻ പോകുന്നത്. നിങ്ങൾ അസറ്റ്സ് റിയലൈസ് ചെയ്ത് കഴിഞ്ഞാൽ നിങ്ങൾക്ക് കിട്ടുന്നത് ചിലപ്പോൾ 1% 2% എത്ര ബാങ്കുകൾക്ക് കിട്ടാനുള്ളത് ചിലപ്പോൾ 1 ലക്ഷം കോടിയായിരിക്കും, 2 ലക്ഷം കോടിയായിരിക്കും. അതിന്റെ 1% എന്ന് പറഞ്ഞാൽ പിന്നെ വേറെ പണിക്ക് പോകണം. ഇദ്ദേഹം പറഞ്ഞനുസരിച്ചിട്ടാണെങ്കിൽ 2 കാര്യങ്ങളാണ് ഉള്ളത്. ഒന്ന്, ഗ്രാജുവേറ്റ് ഇൻസോൾവൻസി പ്രോഗ്രാം എന്ന് പറയുന്ന ഒരു പ്രോഗ്രാം ഉണ്ട്. പിന്നെ രണ്ടാമത് പറഞ്ഞത് 10 years പ്രാക്ടീസ് ഉള്ള 10 years പ്രാക്ടീസ് ഉള്ള ഒരു ലോയർക്ക് വേണമെന്നുണ്ടെങ്കിൽ എന്ത് ചെയ്യാം? 2 മണിക്കൂർ വരുന്ന 100 മാർക്കിന്റെ ഒരു പരീക്ഷയാണ് ഉള്ളത്. അല്ല എന്നുണ്ടെങ്കിൽ നിങ്ങൾക്ക് LLB കഴിഞ്ഞാൽ ഉടൻ തന്നെ ഗ്രാജുവേറ്റ് ഇൻസോൾവൻസി പ്രോഗ്രാമിൽ നിങ്ങൾക്ക് പങ്കെടുക്കാം. 2 വർഷത്തെ. അതിൽ 1 വർഷം ഇതേപോലെ ലോ കോളേജിൽ പോണ പോലെ നിങ്ങളൊരു ക്ലാസ് അറ്റൻഡ് ചെയ്യണം. അതിനുശേഷം 1 വർഷം ഒരു ഇൻസോൾവൻസി പ്രൊഫഷണലിന്റെ കീഴിൽ നിങ്ങൾ എന്ത് ചെയ്യണം? പ്രാക്ടീസ് ചെയ്യണം. നിങ്ങളൊരു വക്കീലിന്റെ അടുത്ത് പോയിട്ട് പ്രാക്ടീസ് ചെയ്യല്ലേ, എന്നതുപോലെ ഒരു ഇൻസോൾവൻസി പ്രൊഫഷണൽ മുന്നിൽ നിങ്ങൾ പ്രാക്ടീസ് ചെയ്യണം. അതിന്റെ കോസ്റ്റ് എന്താ? What is the cost of
12 lakh rupees.
12 lakhs. Peanuts.
Power bank.
Peanuts. 12 ലക്ഷം ഉള്ളൂ. 2 വർഷം നിങ്ങള് UK പോയി പഠിക്കുന്നുണ്ടല്ലോ LLM ചെയ്യാനായിട്ട്, എബ്രോഡ് പോയി പണിയെടുക്കണ്ടല്ലോ, അവിടെ പോയിട്ട് ഹോട്ടലിൽ ക്ലീൻ ചെയ്യുന്നുണ്ടല്ലോ, ടോയ്ലറ്റ് ക്ലീൻ ചെയ്യുന്നുണ്ടല്ലോ. എന്തുകൊണ്ട് 12 ലക്ഷം ഇവിടെ ചെലവഴിച്ചുകൂടാ? എന്തുകൊണ്ട് എന്ന് പറഞ്ഞു കഴിഞ്ഞാൽ എന്താണ്, ഇവിടെ ആരുമില്ല, ആളുകൾ കുറവാ, 5,000 പേരിൽ താഴെയുള്ളൂ. എത്ര ലോയേഴ്സ് ഉണ്ട് നമുക്ക് കേരളത്തില്? എത്ര ലോയേഴ്സ് ഉണ്ട് നമുക്ക് ഇന്ത്യയില്? എത്ര പ്രൈവറ്റ് ലോ കോളേജുകൾ ഉണ്ട് കേരളത്തിൽ മൊത്തം? അതിൽ നിന്ന് 1 വർഷം പാസ്സായിരിക്കുന്ന എത്ര ലോയേഴ്സ് ഉണ്ട്? അതില് അദ്ദേഹം ചോദിച്ചു എത്ര പേര് കോർപ്പറേറ്റ് ലോ പ്രാക്ടീസ് ചെയ്യാൻ താല്പര്യമുണ്ട്? 1-2 പേരുണ്ട്. ഇത് നമ്മൾ എന്ത് ചെയ്തിട്ടില്ല, നമ്മൾ എക്സ്പ്ലോർ ചെയ്യാത്ത ഒരു ടെറിട്ടറിയാണ്. ഇത് ചെയ്യേണ്ട സമയമായിട്ടുണ്ട്. ഇവിടെ നിന്ന് ഇറങ്ങാൻ പോകുന്ന വിദ്യാർത്ഥികൾ എന്ത് ചെയ്യണം? എന്റെ ഒരു അഭിപ്രായത്തിൽ നിങ്ങൾ ജീവിതത്തിൽ നിങ്ങൾക്ക് ഉണ്ടാക്കാൻ പറ്റാത്തത്തോളം പൈസ നിങ്ങൾക്ക് ഇതിൽ നിന്ന് ഉണ്ടാക്കാൻ പറ്റും. കാരണം എന്താ, ഇത് അധികം ആൾക്കാർ എക്സ്പ്ലോർ ചെയ്തിട്ടില്ല എന്നുള്ളത് കൊണ്ട്. പറഞ്ഞു വന്നത് ഇതാണ്, അവസാനം നിങ്ങൾ ഇത് എക്സ്പ്ലോർ ചെയ്യണം എന്നുള്ളതാണ്. ഇവിടെ CA CMA കോസ്റ്റ് അക്കൗണ്ടൻസുകാർ ഇതില് ഓൾറെഡി എക്സ്പ്ലോർ ചെയ്ത് തുടങ്ങി. എനിക്കറിയില്ല എത്ര ലോയേഴ്സ് ഇതിൽ എത്ര പേര് മെമ്പർ ആയെന്ന് എനിക്ക് അറിയില്ല. പക്ഷെ എനിക്ക് urge ചെയ്യാനുള്ളത്, നിങ്ങളുടെ പറയാനുള്ളത് ഇത് ചെയ്യുക എന്നുള്ളതാണ്. ഇൻസോൾവൻസി പ്രൊഫഷണൽ ആവുള്ള ഏറ്റവും നല്ലൊരു ഗോൾഡൻ ഓപ്പർച്യൂണിറ്റി നിങ്ങൾക്ക് ഇവിടെ ഉണ്ട്. മനസ്സിലാക്കിയിട്ടുണ്ടെന്ന് പ്രതീക്ഷിക്കുന്നു. ദാറ്റ്സ് ഓൾ. താങ്ക് യു സോ മച്ച്.
Yeah, I think that being 1 lakh is it's a general theme. There are some concessions also based on the government. It's a government conducted program. There are concessions for the scheduled caste. That kind of some concessions are also there. So, and I will tell you this. This loan, this whatever bank, whichever bank applies, you will get loan. Because you are damn sure you will be get placed at the end of 2 years. New students, they will have to look, the opportunity is good. Thing is, it as a new law 2016 enacted, I qualified in 17. We are new entrants. When I was passing out this exam, there was nobody in practice. In Coimbatore, I am the first person to qualify for the exam. So there are members 15 years senior, they got the membership. So gradually over 5 years we have built up. So we have, for me I handled 20 cases so far. With that decent earnings of 3 lakhs is a normal thing it can come. Just imagine if you can take it up. Thing is, you should have great passion because corporate law continuously evolving. Among all the laws, corporate law is the maximum matters challenge in the court because money is there. People spend big money in corporate law matters. Civil, criminal laws are it's a good practice area, but it doesn't have that much amount of money playing in that field. Very few practitioners will be able to do that. Corporate law is completely different. And given the current industry scenario where everything is gradually getting corporatized, sooner your agriculture business also will get corporatized. Government came out with the act to bring it all corporate into the sector. Maybe unsuccessful now, but it will not be for long term. Sooner they will also get into corporate sector. Everything you deal, everything will be dealt in corporate form. Long run corporate law is a strong practice area where you have great opportunity to stand. So it's a call you can take in the coming days when you get in, whether in which area to practice. And if I have persuaded you to corporate law, then it's great that I got an opportunity to persuade you. Thanks a lot for giving me this opportunity. If you have any specific queries, I am here to answer. Any questions on these matters, on insolvency and company law matters, you can. Looks like post-lunch session I have handled it correct and made you everybody knowledgeable and nothing got into your mind. Either of this. Anyway, there is no question. Thank you. Thanks a lot.
We'll go for the certificate distribution next. കുറച്ച് സർട്ടിഫിക്കറ്റ്സ് ഷോർട്ട് ഉണ്ട്, അത് പിന്നെ കൊറിയർ ചെയ്ത് തരുന്നുണ്ടാവും. ഇപ്പോൾ ഏതാണ്ട് 100 സർട്ടിഫിക്കറ്റ്സ് ഉണ്ട്, ഒരു ഡിസ്ട്രിബ്യൂട്ടിങ്.
we are sure that you will be given a certificate. There is some shortage of certificates. Sir has already assured us that we will be sending across the certificates, and you are sure that you will get a certificate. Okay. Those who are getting it now, happy, and those who get next day, happier. We will follow up next.
Mohammed Shafi. Mohammed Shafi. Umadidi KS. Mohammed Shafi.
ചോദ്യം ചോദിക്കൂട്ടോ. ഈ സൈഡ് അപ്പുറത്തെ സൈഡ്
Umadidi KS. Umadidi KS, please come forward.
കുറച്ചെണ്ണം
Anushka
എടുക്കും.
V. Dinesh.
എല്ലാവർക്കും എടുക്കുക പേന.
Diya Anwar. Anushka V. Dinesh. Diya Anwar. Diya Anwar, please come forward. Zoya. Archana NK. Ahmed Razi. Ahmed Razi. Bhavana PM. Adila Ji.
മാസ്ക് ഇട്ടിട്ടൊക്കെ എന്തിനാ?
ബാക്കിയുള്ള സർട്ടിഫിക്കറ്റ്സ് സെഷനിൽ കഴിഞ്ഞിട്ട് Please stay back.
Stay back for 2 minutes.
Please wait for more than time. Next up, I invite Ms. Salida to propose the vote of thanks.
Good evening to all. I am here to deliver the most cliche yet important part of the meeting, and my duty today is to deliver vote of thanks. There is no need for an introduction for our Honorable Chief Justice, CM Suresh Kumar sir and CAS Prabhu sir. They have enriched us with valuable knowledge and time getting into a discussion with the fellow members of this Institute of Chartered Accountants of India. It is a privilege and we are so proud of the same. On behalf of NSS Unit GLCK and the college, thank you for your works and time. I would like to gratitude towards our newly promoted principal, Mr. Krishnakumar sir, for being the part of the program and giving us all the guidance in play. Cecil ma'am has been the best coordinator in town any NSS unit can wish for. As our team came to an end, we have our Laurelman sir to lead us this academic year. I extend my sincere gratitude to Cecil ma'am and Laurelman sir as well. All other teachers and staff for their time. I am grateful for being a part of this esteemed set of students of this NSS unit. So on behalf of this all unit and college authority, I extended my gratitude and share my happiness all the students who gathered here to make the program a success. Thank you.
Thank you, Alida. Change will not come if we wait for some other person or some other time. We are the ones we have been waiting for. We are the change that we see. Quoted by Barack Obama. Hope you all have a great day ahead. Thank you all. Last speakers, please. After this
കയ്യിലും സ്റ്റോപ്പായി